This is the matter of In re Byron Konschuh, JTC matter. Mr. Campbell, I think we start with you. So you may proceed. This is, you each have 20 minutes of argument. You may reserve some of that time if you would like to, but we like you to try and manage that. You may proceed when you're ready.
Thank you. May it please the court, Donald Campbell on behalf of the respondent, Byron Konschuh, a former 40th Circuit Court judge. I will reserve 10 minutes for rebuttal, please. May I proceed?
You may.
Thank you. This is our petition for review from the Michigan Judicial Tenure Commission's decision and recommendation on discipline. Their recommendation, made while my client was still a judge, was for removal and a 6-year conditional suspension. We are seeking reversal of the counts added by the JTC on review and an order of censure for the violation of count 7 of the amended complaint as found by the master. As I noted, my client is no longer a judge, and therefore the removal issue is moot. That's your precedent under In re Probert, decided about 40 years ago in 411 Mich 201, page 222. That was not briefed by any of the parties, but I assume, given the precedent, that it's not much of a question at all, if any question. Probert was cited with favor as recently as the In re McCree case from 2014. We are seeking reversal of the counts added by the commission, specifically counts 1, 2, 3, 4, and 8. The commission simply disregarded the master's finding of credibility and flatly dismissed the conclusions that he made. The master found that the charges were not proven. In 7 of the 8 counts, he found misconduct only as to count 7, citing a conflict of interest and a failure to disqualify or secure a proper written disclosure or waiver in cases that involve first the old prosecutor and then the new prosecutor. All of these cases were uncontested pleas. There was no evidence of actual bias in the cases. Indeed, the JTC called several witnesses who were former criminal defendants. All agreed that they got the deal they had worked out with the prosecutor. Respondent did make some written disclosures and even updated those disclosures from time to time, but the master found his efforts to be inadequate. My client accepted his ruling. The master heard 23 days of testimony. He heard 39 witnesses. There were nearly 4,000 pages of testimony, 1,000 pages of testimony by my client alone. The JTC cross-examined my client for nearly 700 of those pages. They took 16 days of hearing to present their case. We prevailed on 7 of the 8 counts before the master, largely on the testimony of their witnesses. We also provided the proper context for the facts contained in the 350 exhibits. And, of course, respondents' credibility was the centerpiece of their attack and the cornerstone of our defense.
Mr. Campbell, I'm going to interrupt you because my colleagues might have questions, and if not, you can go on and on. So, or not on and on, but on. I'm going to start with Justice Clement.
No questions right now, thanks.
Justice Kavanaugh.
I just want to clarify with respect to the conditional suspension. Is it your position that you're not challenging the Probert decision or our ability, constitutional authority to sanction your client in the form of a conditional suspension? You mentioned last time applying it in McCree and I believe in Brennan as well, although in those circumstances they were sitting judges at the time that suspension was, but you're correct that Probert was not. But I understand your position is that you have not challenged our ability under Probert to issue a conditional suspension as a sanction.
My position is this, and I'm aware, Justice, of the issue that has come up, I think as lately as the Brennan case, and it has tentacles, if you will, or dashes that go back to McCree and Probert as well, which is cited in McCree specifically. My view is this. There's count seven. Count seven is a censure violation. That's what we've argued on appeal. As to the question of whether you can do a conditional suspension forward, really a prospective suspension, that's a constitutional issue in my view. And as you have said in other cases, the job of the JTC is to make sure that it does its constitutional duty and that the court can do its constitutional duty. So I don't believe that was an issue that needed to be raised in the manner on appeal and addressed in the limited time, either in this argument, although I'm happy to do so now, or in the writings that we've done. But I believe if it's a constitutional issue, as I know more than one justice on this court has noted, I think then it's a constitutional issue that should be considered. I hope we don't have to consider it because of the censure.
If we reject your position that a censure is appropriate or that only count seven is appropriately sanctioned, there hasn't been a position raised that we cannot conditionally suspend your client, correct?
In the briefing, that position has not been raised. I believe constitutionally that's a preliminary or threshold question for this court.
Okay.
And the court believes that it cannot do it, then it cannot do it, whether anybody's argued it or raised it.
Sure. Okay. Thank you.
Thank you. If I may continue, or are there other questions?
I'm gonna let everybody have a shot at you first, and then you may. Justice Welch.
Yes, thank you so much. Thank you, counsel. I just have a question about the issue of the plea agreement to the accounting statute. I know a lot has been made about this in this case, and something this court sees a lot of are appeals that people didn't understand their plea, and we regularly have to make decisions about those. And of course, our trial courts have to make those decisions all the time. I'm just grappling with how it is a sitting judge is saying he didn't understand the plea agreement to be what it was or what he thought it was. And I'm wondering if you can help me understand that.
Well, as the master found at page 5 of his report, quote, and again, this is after hearing my client testify for the first 5 days of the hearing and at the end of the hearing. So the JTC called him first. I reserved my cross-examination or examination of him into my case at the very end. And after hearing not only from my client, but from my client's criminal defense attorneys, both of whom were testified and both of whom were examined significantly by disciplinary counsel during the proceeding. What the master found was, and now, by the way, looking at all the paperwork, including watching the plea videotape during the proceeding. I can't remember if the sentencing was played, but I know that was gone over extensively in the transcript form as well. He found, quote, the prosecutor surprised respondent when she appeared for the post-facilitation hearing with a new complaint. The master was convinced that respondent, this again, quoting from his report, the respondent felt that he was, quote, caught off guard and pressured into an outcome inconsistent with the mediated agreement, end quote. And that agreement, of course, was in evidence. Judges are no different. Be they ex-prosecutors or never having practiced law in a courtroom, judges are no different than anybody else in terms of pressure and circumstances. What was the core of the motion regarding the nunc-pro-tunc was the challenge that was based on those findings that the master confirmed. And so in that challenge, the master's finding was, quote, he being my client, brought the issue before Judge Nethercutt and accepted the court's ruling. Having a court rule against your good faith interpretation of the facts and the law is not misconduct. Of those 39 witnesses, of those 16 days of hearing that the JTC conducted their case, they did not call the prosecutor. She never testified in this case. So their position relative to what the goal of the mediation agreement is not anywhere in testimonial evidence. The only testimony is from my client and his two attorneys who worked through that mediation agreement. You can read that mediation agreement at I think it's I in the exhibits, that clearly states what it is. You can tell how they worked specifically over the wording of that agreement. And yet, it is not what was put on the record, because the prosecutor showed up with an amended complaint that was not part of that mediation agreement. So in context, while it may be difficult in the ether to imagine somebody with all that training, but that training doesn't protect you. And especially now you've had a master, your special master, hear this matter, hear it over the course of 23 days from all the witnesses that the JTC wanted to call. And he concluded that my client's position was reasonable. I hope this court will do the same.
Mr. Campbell, I'm going to make sure Justice Welch doesn't have a follow-up.
No, all set. Thank you.
Justice Sara?
No questions, thank you.
Justice Viviano?
Yes, I have just a couple questions, counsel. One observation, I agree with your reading of Probert, that, and with common sense and ordinary logic, I guess, that we can't remove your client from an office that he no longer occupies. But Probert does, of course, then go on to say that we can conditionally suspend someone who's no longer in office and censure a person who's no longer in office. And apparently you're asking for a censure. And so you seem to be in agreement with that decision. But I just would make the observation that I thought that Justice Levin, in his lengthy and thoughtful dissent, raised some very interesting points about whether conditional suspension and even censure goes beyond our power when it comes to former judges. And so I, for one, would like to see a party raise that issue so we could maybe address it and perhaps revisit that issue in a future case. Having said that, I have to say that I'm struggling with the exact topic that you were just on with respect to the master and the notion that your client, as a former assistant prosecutor, former county prosecutor, and now former judge, involved no doubt in thousands of plea negotiations and plea hearings, took the position that he pled no contest to something that was not a crime. And then he was sentenced and placed on probation for something that was not a crime. I think you've described that as a good faith interpretation of the law. And I have to say, I'm struggling with that. Can you help me to understand, when is it that someone gets to plead guilty or no contest to something that's not a crime? When does that happen exactly?
Yeah, if I may, in terms of correcting the record, there was no probation. There was a plea, and there's disagreement over whether that plea was even accepted. You can read that in the briefs. And then
let me amend my question. There was a pre-sentence investigation and report for something that was not.
That was the common thing for the judge to do. He said that, and he did a pre-sentence report, and then there was a dismissal hearing that followed, and that was consistent with the agreement that had been reached in the mediation. But as you say, how can you plead to something that is not a crime? And the answer to that is, I've always understood, and I started my career decades ago now at the Oakland County Prosecutor's Office. When I did, there was no retail fraud. What there was larceny in a building. And we used to plead people down to attempt larceny in a building. And you may not know this, although some of you may have taught criminal law, that's not a crime. And there were other instances, and I'm aware of instances that there are circumstances where the prosecutor and the defendant agree on a charge, and they agree between themselves to call it something which can be pled to. And that is
that is a questionable practice, something that we're actually thinking about administratively in relation to one of our rules. But even under the fictional crime scenario that you're describing, it's still a crime. In other words, the under the attempt statute, it, I think, cuts the penalty in half and so forth, and the person's sentenced on a criminal offense. May not be one that's technically on the books or technically legally even possible. Everyone understands that that's a criminal matter, not a civil matter, not a probate matter. It's a criminal case.
It's my recollection is, Your Honor, that It is not a crime, and that's what the case law says, that you can plead to crimes that don't exist. That's a summation of my recollection from 37 years ago in that role. It is not that unusual. And here's a place where being a prosecutor actually probably puts my client in a different position, where he has had other circumstances where there are pleas to things that aren't technically crimes. And here, the prosecutor Finnegan, when you read that mediation agreement, she does not put in 750.485. And so, again, if you're the prosecutor and if you need a crime of the type that is under 750, why was that not there? Why didn't she recognize? You had Mike Sharkey, who is an experienced criminal defense attorney. He doesn't raise it during the mediation. You have Judge Ransom, who conducted the mediation, had them sign a written agreement, and it is not there. In order to preserve some time for rebuttal, I would conclude my remarks now, if I may, unless there are more questions.
No such luck, sir. Mr. Justice Bernstein gets also Justice Viviano. Were you finished?
Yes, I appreciate your response, the counsel.
Thank you.
Justice Bernstein, do you have any questions at this point?
I do, and I have to say, Judge, I have to say, first off, I totally empathize with you on the technology front. So you and I I just want you to know I totally get your struggle with technology, because during this pandemic, blind people have had the same challenges. So we're totally on the same page. So one thing I just want to say is, I love your passion, and I enjoy the passion that you kind of bring to your argument. But I don't have any questions, because ultimately the question I had was posed by Justice Viviano. So I'm good to go. Thank you.
Okay, you may reserve 3 minutes and 23 seconds. Mr. Murphy, you may proceed.
Thank you, Chief Justice. May it please the court, William Murphy, Dyke Magassett, appearing on behalf of the Judicial Tenure Commission. Before addressing the substantive reasons that the 9-member commission unanimously found misconduct and recommended removal, conditional suspension, and cost, I want to make a couple of observations. First of all, although a crime and a plea to a criminal misdemeanor occurred here, this is not a criminal case in front of the court. This is a civil proceeding. The standard of proof by the commission is preponderance of the evidence, not guilt beyond a reasonable doubt. So the question becomes, does the record tilt in favor of the conclusions and recommendations made by the Tenure Commission? Secondly, some of the misconduct by the respondent occurred while he was a prosecutor. This was before he was a judge, and it occurred during his 13 years as prosecuting attorney in Lapeer County. As a lawyer, he was subject to the rules of professional conduct, and this court has jurisdiction. Mr. Campbell spends a lot of time talking about the master's finding, but this court is committed to reviewing the recommendations of the Judicial Tenure Commission, not the master, and the review is to be de novo. The Supreme Court generally will defer to the commission's recommendations when they are adequately supported by the record, and I submit that they were in this case. The commission's responsibility was to review the actions of the respondent in an objective manner. Now, as Mr. Campbell indicated, the respondent was not reelected in this last election, so he is not a sitting judge. We submitted, the commission submitted their decision and recommendations in August of last year when he was a sitting judge. The commission asked for removal, conditional suspension, and costs. Based upon the Probert decision, on behalf of the commission and as an officer of the court, I would recognize that the issue of removal is moot. Probert decision is clear that if a judge is not sitting in that position, removal cannot occur. But the commission has asked for a conditional suspension and costs. The Probert decision was clear that if a judge resigns or if a judge is not elected or reelected, the commission still has the authority to issue a conditional suspension and even a censure, as they did in the Probert case. In other words, they found that removal was moot, but they they decided that there should be a conditional suspension and a censure. And I think this court, with the Probert precedent, is with complete authority to do that if it so desires.
Mr. Murphy, let me interrupt you and get to questions, and then we can return if
Sure.
there are not very many. So I'm going to start with Justice Clement again.
Thank you. It seems like the JTC did not take into account some of the mitigating factors, and the one that comes to mind is that respondent claimed that he was following the chief judge's instruction regarding disclosing conflict of interest and disqualifying himself. Is that something that should change the sanction?
Justice Clement, I don't see why that should change the sanction. First of all, there was no testimony from the chief judge that that's what was recommended. But let's assume for the moment that that's accurate. The judge himself had responsibility to function in a fair, impartial manner. Here is a judge who had in front of him cases dealing with 3 attorneys, but particularly 2 attorneys, Mr. Sharkey and Mr. Turkelson. Mr. Sharkey had been representing him for more than 2 years at a considerable involvement dealing with the preliminary exam on his embezzlement charges, dealing with taking that decision to the circuit court, losing at that stage, trying to take it to the Michigan Court of Appeals, being denied leave to appeal, denied reconsideration, sought leave in your court, and denied leave there. Mr. Sharkey had spent considerable time, and I think the record will reflect that even the respondent indicated that he was going to owe him a substantial sum of money. The reality is Mr. Sharkey billed him in excess of $400,000. That had not been paid. Any judge, I submit, hearing matters that deal with a client of an attorney to whom he owes $400,000 or substantial sum, an attorney whom he inappropriately endorsed for a prosecuting attorney, they would at least disclose that. I suspect that they should disqualify themselves, but at least they disclose it. With respect to Mr. Turkelson, there was animosity there by the respondent to Mr. Turkelson because he blamed him for these criminal charges that were brought against the respondent. He needed to at least disclose that. So, you know, the fact that somebody may or may not have suggested that you can hear things that are not substantive, who knows what was substantive? He had the obligation and the duty to come forward and disclose the situation and then, frankly, disqualify himself.
Justice Clement, do you have a follow-up?
I do not. Thank you.
Justice Kavanaugh.
No questions for me.
Justice Welch.
No questions.
Okay. Justice Zara.
Thank you. Mr. Murphy, on my time here on the Supreme Court, I have struggled with this notion of conditional suspension. My first encounter was in re Sylvia James. In that case, the respondent, Judge James, was on the ballot. Our decision came out, I believe, after the primary, but before the general. And I was not inclined to do a conditional suspension because at that point I felt that we should leave it to the voters to decide. all of the information giving rise to the action against Judge James was well known to the voters, and I felt that it was inappropriate for this court to take it away from the voters. Yet a few years later, in re McCree, where there was no election pending or present or near, and then again in re Brennan, same situation, no election. I joined the group, I think the majority, in indicating that a conditional suspension was appropriate. I'm not particularly satisfied with the standards I've personally developed. What would you do? Can you help me come up with a set of factors as to when it is appropriate and is not appropriate to do conditional suspensions?
Justice Zara, with the concept of leaving it to the voters, as a attorney and as a former judge who lost 2 elections to the Supreme Court, I'm not sure I'm the best person to answer that question. But let me say this. The difference here in James, the court spoke to the misconduct that had occurred. The court spoke by removing her. It chose not to deal with a conditional suspension, and I suspect that part of the reason was that they had spoken and they had removed her, and they had said to the public, this is the kind of conduct that is unacceptable. In this case, we don't have that option. The Supreme Court cannot remove the respondent. This was well publicized in the area. Frankly, the whole situation was a scandal to the court. And I think it's important that this court speak to that so that the public knows that the conduct that occurred here is totally unacceptable. And it takes more than a censure to convey that to the public and to restore the public's confidence in the judiciary. That's why I think a conditional suspension is called for. I guess I'd have to leave it to all of your good judgment as to how you determine the criterion on a case-by-case basis. But in this case, it's called for. There were, misrepresentations. He pled guilty to pled no contest, to a misdemeanor crime. He took money that came to him in his official position as prosecutor and placed it into his own personal bank accounts with his wife, bank account with his son. He then dealt with these attorneys and their clients who came to court to look for a fair and impartial jury, fair and impartial judge, and had to deal with someone who the record shows had bias either in favor of or opposed to the attorneys that were representing those people.
Okay, thank you very much.
I did it. It took me 3 cases. Justice Viviano.
Yes, thank you, counsel. My question is most of seems like a lot of the conduct at issue in this case was pre-bench conduct, all of the financial allegations of financial irregularities, except for the conflict of interest, which you just discussed, charges, and the misrepresentation about the plea deal issue that I was discussing with opposing counsel. But it seems like a lot of the time and effort in this case dealt with pre-bench conduct, and now the voters have spoken, and like you, I've lost an election, but I still have some faith in the voters, and they've already spoken on this matter. And I guess one other thing I would recognize, this case has taken a long time to get to us, unfortunately. And the JTC's invested a lot of resources into it. But having said all of that, why not let the AGC handle this case at this point, since most of it seems to deal with conduct that occurred before this individual took the bench?
Well, Justice Viviano, it's true that the embezzlement of the money took place when respondent was a prosecutor, but this didn't all take place prior to the respondent being a judge. In addition to not disclosing and or recusing himself, when he was a judge, he filed a motion with Judge Nethercott, a nunc-pro-tunc motion, where he claimed that he did not plead no contest to the misdemeanor. The record is replete with information on that. You have exhibits that show a plea agreement and a sentencing agreement that he signed, specifically referencing the misdemeanor violation. Now, Mr. Campbell talked about surprise, caught off guard, etc. But he was there with at the plea stage with two attorneys and himself as a judge, never once mentioned a concern about the reference to the misdemeanor statute. But in front of Judge Nethercott, as a judge, he represented in his motion that he did not plead to the misdemeanor. This was action taken as a judge. As a judge, he filed a civil suit against Mr. Turkelson and others. And in that civil suit, in the deposition, he claimed that he did not plead to a misdemeanor, that he did not have a conviction for a misdemeanor. So while some of the action took place when he was a prosecutor, certainly as a judge, he had to know his responsibility to honor the oaths that he took when he gave testimony. And he continued to, as a judge, deny his plea in front of the commission, in front of the master, and frankly, even in front of this court. So I wouldn't limit it just to the embezzlement aspect of this. It's conduct that he undertook when he was also a judge.
Yeah, no, I mean, my question sort of built that in. I'm not that impressed with his representations that he made in reference to the plea agreement and the conviction that occurred in this case, even if it was later, the case was dismissed. But I guess my only point is a lot of the time and effort had to do with the embezzlement. And that all seems like that was all pre-bench conduct. I guess let me ask you one thing about the misrepresentation, because I think that does, to my mind, go to the heart of the JTC's former request for removal and now the current request for a conditional suspension. I'm sympathetic to your view and to what you're advocating with respect to that, to the representations that were made. But playing devil's advocate for a moment, what about the notion that those representations were so silly that nobody bought it? He apparently didn't convince anyone of it. It's almost as though he was sort of, I don't even know how to describe it, but whatever he was trying to peddle was not selling. It didn't seem to sell in the civil case, certainly didn't seem to sell in front of Judge Nethercott. What about that? What about that notion? I mean, in other words, if he intended to deceive, he was pretty inept.
Throughout these proceedings, Justice Viviano, a respondent has exhibited a pattern of dishonesty, deception, and misrepresentation when he was a prosecutor and then when he became a judge. He's blamed others and essentially taken no responsibility for his actions or shown any remorse. And even now, he's inviting this court to join him in his alternative universe. And this is an invitation, frankly, that the court should decline. This respondent is not fit to serve as a judge. And since you cannot remove him based upon the Probert precedent, the action that this court should take is to issue a conditional suspension.
All right, thank you, counsel.
Justice Bernstein?
Hi, good morning, counsel. And I have to say, it's a pleasure to have you in the Supreme Court. Thank you for coming and joining us today. Just a quick question, if you could help me with this. And this is just kind of my one concern, and perhaps you can guide me through it a little bit. My concern is that, brother counsel argued quite a bit about the, special master. There was a very long proceeding. You had a very lengthy transcript. And I guess my question is, and I understand the how it works and the structure and all that kind of stuff, but what are we to make of the fact that the special whether I understand it's de novo, I get all that, but my concern here is the validity of a special master. If we're going to go through the process of appointing a special master and having a hearing, what credence is our court supposed to give to that? And what ultimately is the role of the special master if we're not going to really give tremendous credibility to the findings of the special master?
Justice Bernstein, I didn't mean to suggest that the court cannot consider the master, but that's not whom the court is doing a de novo review of. I don't know that time permits, but the commission decision, as well as the commission's written reply to the respondent's petition, sets forth in great detail and focused on the record that supports the conclusions reached by the tenure commission. And in both of those documents, it sets forth, I think, in pretty adequate detail where the master may have gone down the wrong road. For example, the master talks about the surprise at the plea and that this wasn't contemplated. Yet, again, with the plea documents itself, the respondent signed a plea and sentence agreement where it specifically mentions the particular statute involved. So with all due respect, I think that the master just did not focus as specifically as needed on what that record showed. And again, there are decisions from this court going back years where the master may have made certain findings and the commission made different findings, and the court subscribed to the commission's findings. And that's what I would suggest should occur here. And bluntly, the commission did accept certain findings of the master where the master focused on things in a way that might be a credibility determination. For example, with respect to the respondent's conduct with one of the civilians during the election process. The commission found support for the master's view that the disciplinary council had not proved that by a preponderance of the evidence. So the master was not ignored in this process. The master was considered by the commission. It's just that they reached different conclusions based on the record.
Thank you, counsel. You answered my question. I appreciate it. Thank you, and welcome again.
Thank you.
Justice Kavanaugh has another question.
I do, and it'll be brief. And it's really, I would just like your take on this, Judge. And it touches on something that I think Justice Viviano raised, that I think frequently is the case that, or certainly it sometimes is the case that if a judge is under investigation or scrutiny for some conduct, they may resign from the bench, or let's say perhaps they don't get reelected. And the JTC loses jurisdiction to do anything with regard to that misconduct, but that's still, that judge, who's also an attorney, is still subject to potential discipline by the AGC. If we are to issue any kind of sanction for the conduct that is encompassed in this complaint, the vast amount of conduct, even if it's a conditional sanction or conditional suspension, if we exercise and impose a sanction, does that mean that now that he is no longer a sitting judge and would in theory be subject to the AGC, that the AGC is precluded from sanctioning him for this conduct, including in theory up to the point of disbarring him from practicing law? Would we, if we act in any regard, does that then strip the AGC of the ability to sanction this conduct as well?
Justice Kavanaugh, it isn't part of this record, but if you're asking me to address that generally, this court in the past year or so made a decision with respect to Justice Brennan with removal and other penalties. I read this, so I'm speaking from what I think is accurate, but general information is that the Attorney Disciplinary Board recently removed her from being a practicing attorney. In other words, disbarred her. So I guess the bottom line answer your question, I don't think a decision by you would prevent the Attorney Grievance Commission from doing whatever it's authorized to do.
Okay, thank you. I appreciate it.
Thank you, Mr. Murphy. You are out of time. Mr. Campbell, you have a few minutes of rebuttal.
Thank you. I'd like to address a couple of points raised by Judge Murphy in his statement, and I'd like to address the last point if I could get through my other ones. That's the incentive. As to the question of what you review, Judge Murphy echoed actually footnote 1 of his brief in reply by saying you don't review the master's findings. That's not accurate. This court reviews the record de novo. That's MCR 9.252A. So you do get a chance to look at what the master says. More than that, in Ray James, you relied on the master and you cited the fact that the master in that case had a superior position in determining the credibility. Here, it is a far superior position given the days of hearing, the amount of time that the JTC spent with my guy. And they could not convince the master. And of course, we were able in defense to set aside the other charges, one of which is this embezzlement claim. And the reality is their mountain of embezzlement claims at counts 2, 3, and 4 are really just molehills of an accounting dispute between the executive and the legislative bodies in the county. Judge Nethercutt at the plea summed up his understanding of the facts. Quote, actually, I've looked through it many a times, as you know. I'm not going to take the time today. He was talking about the preliminary examination transcript. I'm not going to take the time today because what I remember is when Mr. Konschuh was county prosecutor that he came into possession of a small amount of money, which was not accounted for in the way that the county treasurer wants. And there was not an exact record kept of that money. That was the preliminary examination where my client didn't defend himself. We defended ourselves. I defended these charges here, and we were able to convince and satisfy the master that that's exactly what happened here. It wasn't an embezzlement. It was a dispute over how you deal with monies that were part of a contract that named the Lapeer County prosecutor as the signatory to the contract. And again, even the county controller, who was the expert witness in the preliminary examination, came in and talked about how everything was iffy, fuzzy, foggy, and unclear or gray on these things by the time had passed and he had more time to consider this. Lastly, Prosecutor Finnegan expressed the same sentiments. Again, she wasn't called by the JTC to say anything different. She at the plea hearing, she said, this was at the dismissal hearing, quote, it was never the goal of the prosecution to hang Mr. Konschuh with a felony. It was a goal to acknowledge that something adverse had happened. That's what MCL 21.44 says. That's exactly what they mediated. And again, this construct of embezzlement, these construct of misrepresentations, they are entirely in the mind of the JTC. And frankly, you're right, this was a long case. They have been investigating him since 2004. They didn't get around to prosecuting him to 2019. It turns out 5 years is too long to let charges marinate at the JTC for them to give them up after a master tells them that they are wrong. Now, a little less passion for this one for everybody. The questions come up, what happens depending on your decision? There is a court rule, Michigan Court Rule 9.116B. I have practiced grievance work for the last 28 years, and I don't know that I've ever had a chance to cite it, and now I have to remember it. 9.116B says that a judge who is not removed is not under the jurisdiction of the Michigan Attorney Grievance Commission and cannot be prosecuted. So that is what that rule says. You can read it. Again, I have not recounted it word for word, but I think I have the essence of it. I wanted this court to understand that from the questions that have been raised. I think possibly you didn't have that understanding, at least until I said it.
Mr. Campbell, let me see if anybody has any additional questions for you. Are there any additional questions for Mr. Campbell? I don't see any. So if you would like to conclude, your time is up as well. We will hear out your conclusion.
Thank you. I appreciate that. When the master superior position in giving the proper credit is given the proper credit, when the case is viewed not through the lens of those who initiated the charges, but through a fair review of the facts and circumstances, the violations added by the commission on review should fail, and a censure for the violation of count 7 is the appropriate outcome. Lastly, I will offer that if there's an interest, as you know, this court can have us now brief the issues of removal and even conditional suspension now that the election has taken place, now that the political process is completed, which wasn't true at the time of the briefing in this original matter. And I offer the opportunity to do that if it's the court's interest to address the question that has been raised in James and maybe even as early as Probert. Thank you.
Thank you, counsel. Thank you both. The case will be submitted. We're going to be in recess now, and we will be back here in our Zoom courtroom at 12:30. Thanks, everyone.
Thank you all. Thank you, Judge Murphy.